G'day everyone, and welcome to what is our second video update for 2022. Hopefully this is actually the theoretically the 14th video of ours that you've watched as you've worked your way through Area of Study 1 of Unit 3, because we are up to 3.1.14. But this is the second one that we've updated in 2022. The reason being that this is reforms and recommended reforms, and the key thing there is recent reforms. So it's something that does need to be updated quite regularly as reforms become less recent or new reforms pop up. So we'll run through a bit of that today. Filming today from the beautiful Coffin Bay caravan park after a delicious lunch of oysters that Coffin Bay is famous for. So hopefully that's going to pep me up a bit to really, put some juice into these reforms and recommended reforms, and make them so that they're going to be easy for you to remember when you're using them on a SAC, potentially within the next week. If you're watching this straight away, or certainly in an exam at the end of the year, when often we're trying to go back over these things. Quote today, I just want to stop on quickly before we jump into it. I really love this one. Be somebody who makes everybody feel like a somebody. And that's my challenge for you today if you're watching this. It's really easy when we're in a bit of a stressful time, as a Year 12 is, particularly, I imagine, again, you've got a SAC coming up, or maybe it's, in the lead up to the exam when you're watching this. It's so easy to just get stuck in focusing on yourself, and in a way being perhaps even a little bit selfish. Like, it's stressful, you're worried about your own performance, you become a little bit insular like that. This is just that reminder that, hey, you know what, just find something today that you can do that's going to make someone else feel good. Step outside yourself for half a second, and you'll get that back in spades in terms of feeling good about yourself for doing something nice for someone, and the karma that comes from that. So my challenge to you today is go out there and do something nice for someone else, be it someone at home, messaging a friend or something like that, and I'm sure you'll feel great in response. So look, as I alluded to, or directly referenced before, we're going to talk today about recent reforms and recommended reforms to the justice system. So these are changes that we have made to the system that are helping us achieve those POJs of fairness, equality and access. So I want to make the really clear distinction here. Later on in Unit 4 you're going to learn about law reform and just any change to the law that Parliament makes. This is not what we're talking about here. We're not just talking about law reform and changes to the law. We're talking about actually really specific changes to how our justice system operates, to the processes and procedures in that system that are trying to improve that system, so improve or enhance the POJs for every stakeholder. So it could be a change that's intending to make it fairer for victims. It could be a change that's intending to make it fairer for society as a whole, maybe something more equal for an accused person. Any stakeholder at all, any change we've made to the system that improves our justice system for those people. We're also looking at potentially future changes as well that we could make. The skill here, and we'll go over that again in more detail like always later, is discuss. So really the idea of a discussion here is having that in-depth thought process around what's the issue, like what's going wrong in the system at the moment, which principle of justice maybe isn't being promoted as well as it could be, and then why did we make a change to improve that? What was the purpose of that change, as opposed to just remembering facts about a change. It's really going into more depth around, analysing why is this change making the system better. So we'll talk about that later on. Ultimately, you're going to walk away from this video, if I meet my purpose and intention, being able to answer what are some recent reforms and some recommended reforms that will improve the criminal justice system, and a little bit as well with, how will they improve the criminal justice system. So we'll kick in with recent reforms. The key thing here, you'll note, is last 4 years. Now, if you're using an older textbook, which most of the textbooks were printed with the new study design back in 2017 and authored before that, you might be wondering, okay, is my reform outdated? Is it something that I can still look at? Let's consider, for example, maybe a reform that came in February 2018. So if we then go 2019 is 1 year, 2020 is 2, 2021 is 3, and 2022 is 4 years. So Feb 2022 would be 4 years, so last month. So you might look at that, say you're looking at that in a textbook, or your teachers taught that to you. You might look at that and go, well, it's been 4 years and 1 month. Does that mean I can't use that on an exam? And I've previously reached out to the Victorian Curriculum and Assessment Authority about this and got a really clear answer that they're taking reforms on a year-by-year basis. So even though this has gone past 4 years now in terms of like from the date it was introduced, it's actually still within the 4 year time frame because it happened in 2018 and it's now 2022. So if you do any reforms in class more or less that have a 2017 on them, that's a big no. That's technically outside the range. It's probably risky to use that. Okay, it's risky to use something from 2017 because an examiner might mark you or not give you marks for that. So you want to be using anything from 2018 plus, and the reforms that we go through here are going to cover that range. So we'll jump in. First reform, just did an updated video this week on plea negotiations and sentence indications, which goes over this in a lot more detail. But that's because we have made a change in February 2022, so this will exist and is able to be used on exams right up to 2026. If you're having a fifth crack at VCE Legal Studies then, I'd probably be very worried, but hopefully you might, potentially you could have gone off to uni then and be back in school teaching. So this is really hot off the press. It's a great reform for you to remember, because you also have to learn what sentence indications are and how they meet the principles of justice anyway. So in terms of like getting bang for your buck, killing two birds with one stone, this is one of the best reforms that you can learn, and it's one of the reforms that I would really, really, really recommend you have in your arsenal in terms of answering questions about reforms. So, as I said, early 2022, this law passed and came into effect, and an accused person is now able to receive an indication of both what sanction they would receive. So, hey, if you plead guilty now, you will receive a community corrections order, and the duration of that. And I would impose the community corrections order for 24 months. What that means is, if the accused person then proceeds to plead guilty at the earliest possible, or plead guilty at as soon as they receive that indication, so you would suggest, once they've talked to their lawyer within days, the accused person cannot receive a sentence greater than that. That's a really, really important thing. The indication caps the sentence, and they cannot get a sentence greater than that, even if new information comes to light. Now, why this is a reform is sentence indications exist previously, but the previous scheme only allowed you to find out whether you would be sent to prison or not. So will you be sent to prison or not? Not how long you would be sent to prison for. If you're not sent to prison, how long your CCO might be. It would just be, hey, prison or not, yes or no, and then trying to make a decision on pleading guilty off that. This new one, as I said, will both tell you what sanction you're going to get and how long that sanction will last for. What the idea is if, and this is coming to why, why are we implementing this? How will it improve the principles of justice? So theoretically, if an accused person can receive more information about what's going to happen to them with a guilty plea, so if they have a greater understanding of exactly where they will end up and for how long if they plead guilty, theoretically, that is a greater incentive to plead guilty. It gives them more clarity around what's going to happen to them, and therefore leads them to hopefully enter a guilty plea. The reason that we've done this is because of COVID. That's really the central justification for this change. Is we have such a big backlog in our court system right now. We weren't able to hold jury trials for well over a year, and all of those trials cases need to be heard at some point. The theory is that allowing a broader sentence indication scheme, allowing an accused person to get more information about what will happen to them if they plead guilty, should further promote guilty pleas and clear cases from our court system. So the purpose is definitely centering around access and improving access by removing a backlog of cases. On the previous scheme as well, just a side note that's worth including, the prosecution used to be able to block a sentence indication, just say no, but the reform now removes that ability. The prosecution can oppose it, and then you would go to court for the sentence indication hearing, essentially, and the prosecution would put forward why they don't think the accused person should get one. And often that is going to centre around, and they have to check with the victims, often that's going to centre around the idea that a sentence indication is given off the facts and the evidence, so a judge can see the facts and the evidence of the matter, but they don't actually get to see in-depth victim impact statements like they would see in sentencing. So a judge might give a sentence indication and not truly understand or take into account the trauma that a victim has suffered, and as a result the indication could be too light or too lenient. So the prosecution does have the ability to say, hey, we're going to oppose this, and that would most likely be on grounds that we don't think you have enough information to give a true and proper sentence indication. And the court might go, great, yep, we agree, we're not going to offer this person a sentence indication. So that's an important thing to note. But centrally, how you want to explain this, the really important change is that the scheme is broadened. The scheme has been made bigger to achieve the principle of access realistically. The other one that happened again because of COVID-19, and this is an interesting one. There's potentially an argument that because this reform has actually been rolled back, so it's been repealed, so this isn't currently happening anymore. But my understanding would be, and I know that examiners usually are told to look to mark positively. The reality is this change happened, even though it has been repealed. This change happened. The justice system was reformed for a period of about 18 months. Therefore, it remains a reform that occurred, and it's a reform that you can talk about as a reform that happened. I think that's a really important point. So this was in 2020. Again, I just spoke before about this big backlog of cases because during COVID-19 we couldn't hold jury trials. What happened was, or with all of the lockdown restrictions and things like that, the court was rightly very worried about continuing to hold trials where they're bringing in hundreds of people from all around Melbourne into one building to sit in rooms together and then be put onto juries. Now, you can imagine with COVID running around how bad that could have been for infection and spread. So jury trials were shut down in line with COVID restrictions, and straight away cases start piling up because crimes are still occurring, crimes are waiting, criminal prosecutions are waiting to proceed to trial. So the government looked at this and said, you know what, we're going to pass a law that allows people to ask for a judge-only trial for indictable offences. So what this law allowed was people to basically say, I don't want it heard by a jury, we're just going to make our arguments to a judge. So the central elements of this are the accused person had to agree to it. So the prosecution couldn't force someone to take a jury-only trial. We know the right to trial by jury is a really central right that an accused person has. So they would have to really agree and waive that right and say, yep, I'm happy to have a judge-only trial. And the court has to then look at their decision and be like, great, did they make that decision based on legal advice that they had? So that's a really, really important thing. Once you then run the trial, the judge basically operates like the jury, but they also operate like the judge at the same time. Now, having done Q&A sessions with judges over the past couple of years and doing a Q&A session with a judge who was hearing a judge-only trial, that judge talked really clearly about the challenges that they face. Because usually in a trial, what you would do is the jury gets put forward the facts and the evidence that is agreed upon by the judge as being probative evidence that proves something. Occasionally, something might come up in a question, or a party might want to put forward a piece of evidence that it's questionable about whether that evidence should be put to a jury. And in a criminal trial, what will happen is the jury will be sent out of the room, and the judge and the lawyers will talk about whether it's appropriate or not. The jury doesn't hear any of that. So the jury doesn't hear any information that could prejudice their decision. Once it's been decided what's going to happen, the jury will come back in, and the jury will only continue to hear evidence that is allowed by the judge. When you have a judge-only trial, you don't have a second judge that's hearing that while the other judge steps out. So this was the real challenge that this judge spoke about. She said it is an ongoing challenge to really know when I'm sort of, in a way, putting on my judge hat versus putting on my jury hat. So knowing that I have to hear things that could be prejudicial, and I can't allow those things to then impact my decision down the track. So you can see that there's potentially issues with fairness there, in terms of the judge hearing prejudicial information. But effectively, the judge takes on the role of the jury. And what's different to this type of trial than a jury trial is a jury just gives their decision and walks away. They don't have to explain why they made their decision. But in a judge-only trial, the judge would actually have to explain why they applied the law the way they did and what facts they relied upon. So it's actually, in a way, more transparent and more accessible to have a judge do that. Again, the whole idea was trying to reduce delays. If you could have more cases heard judge only, there's less cases backlogged or built up when you go back to jury trials. So, talking about that skill, I'll whip through this pretty quick because I've covered it kind of talking about them both. Discussion. Again, exchange of opinions. So thinking about a little bit as well, what issues could these reforms pose? Look, I think you'd be really, really unlikely to be asked to discuss a reform. I think most likely the question you may be going to get on an exam, I'll show you one later on, is more around identifying or understanding the challenge that the legal system was facing, and then why the reform is attempting to fix that challenge is the more likely question, and where the discussion is going to come from. So just thinking about broadening sentence indications, it's all about intending to reduce delays, by promoting guilty pleas with the further information, which really comes back to access. Argument for equality there as well, because you're broadening the scheme, which means more accused people should consider getting a sentence indication as well, which improves equality across every prosecution, but really centrally focused on access. Again, though, it could limit access in the sense of victims can't put forward a victim impact statement as part of a sentence indication process that they would usually get as part of sentencing. So there's some issues with access for those stakeholders. It could also lead to a lack of fairness if the sentence ends up being too light. That's unfair on the victim. It's unfair on society as a whole. So things to consider there. Judge-only trials. Again, you could argue fairness because a judge is a legal expert, so they're going to be better placed to make a probative a decision based on the evidence alone, not any prejudicial factor, rather than a jury. And again, it's all about access, trying to overcome the delays caused by COVID. What are the potential issues? It limits equality because trials start being done differently. You could be charged with the same offence, but someone gets a judge-only trial, someone gets a jury trial. The idea that the accused has to consent really, though, means that you've got the choice, which does ensure equality to a much greater degree. And there's an argument that it limits fairness. Like I said, a judge is hearing potentially prejudicial information and then making the decision. We back a judge as a legal expert to be able to do that, but it is maybe less fair than a panel of your peers like a jury is. So just things to consider if you think more deeply about the POJs. Recommended reforms. Now, this is from the old study design in an old examination report when it was talking about recommended reforms to the justice system. There was a point made that the reforms can't just come up out of the blue. They have to be ones that kind of we know people have people in prominent positions have suggested, or reforms that or recommended reforms that have been recommended by legal institutions or bodies. And generally speaking, all your examiners are going to know the main ones, So it's important to try and stick to the really main recommended reforms to show that you're not just making up some kind of change out of the blue. You're not just being like, I think maybe a recommended reform would be to get rid of lawyers. Yeah, because, lawyers are too expensive, so, equality, everyone can just do it themselves. That's not going to fly as an answer, because you've really just made that up. There's no one out there recommending, no prominent legal body saying, hey, let's get rid of lawyers in criminal matters. So just making sure you don't make these up. You are coming up with a recommended reform that is widely known and has support from different bodies. Now, as I said with sentence indications, it's a great reform to use because you're killing two birds with one stone. You have to learn about sentence indications. This is another great way of killing two birds with one stone. This is the recommended reform to abolish the test for committal hearings. Why you're killing two birds with one stone is later in the year you need to learn about the Victorian Law Reform Commission and a recommendation it has made to change the law. If you learn about this as a recommended reform now, you're kind of doing your work for later in the year as well. Plus, you have to learn about committal hearings anyway, so you understand them. So this is a great one to have in your arsenal to use in an exam because it's killing or covering multiple points from the study design in the same go. Now, this recommended reform, as I said, came from the Victorian Law Reform Commission. They did a big investigation into the committal system because the government was really worried about, hey, the committal system seems not to be working very well. And part of that is here. So as we know from learning about committals, right, the whole idea of a committal is a magistrate analyses or looks over the evidence, usually in a hands-up brief, and the magistrate decides, is there enough evidence here to lead to a conviction in a higher court? So could a properly instructed jury in a higher court reasonably convict a person based on what evidence is in front of me? The idea being that you're not going to send weak or spurious or needless trials up to the higher courts. Only cases that are likely to succeed are going to go to the higher courts. Really, theoretically, great idea. Weed out the cases before they take up the higher court's time, right? You'd rather get rid of something after a 2-3 day committal process than have it go to court for 3-4 weeks, take up the courtroom, take up a jury, take up a judge, and in reality it was pointless. They were never going to get a conviction. The issue with that is that currently only 1 to 2% of committals result in a discharge. So only 1 to 2% of committals lead to a magistrate saying not enough evidence. Sorry, not enough evidence. The evidence is not of sufficient weight. So it doesn't matter how much evidence there is, it's the weight of the evidence. Currently, 1 to 2% of committals lead to a magistrate saying the evidence is not of sufficient weight. But once you then go to trial, 30% of trials lead to an acquittal. Okay? 30% of trials, a jury is not able to make a finding of guilty. So something's going wrong here. There's this huge gap between what magistrates are viewing as appropriate evidence and then what's actually happening, or evidence of sufficient weight, and then what's actually happening at trial. So realistically, that means our committal process is a waste of time. And it's also causing added stress and trauma for victims, because often committals can be contested, which means a victim and other witnesses might need to come to the committal to give evidence. They might even be cross-examined at a committal. And then if it's committed to go to trial, because only 1 to 2% aren't, they have to do that again at trial. It can be really disheartening. It can be really traumatic. They've got to relive the scenario of the situation that caused them harm, or is alleged to have caused them harm, twice. For what reason? Apparently none, because they're not getting discharged. So it's really ticks off a number of principles of justice here around why we would get rid of the need to establish a prima facie case and instead make it a bit more of a formality. Actually acknowledge that, hey, it's a bit of a formality already. The magistrate just instead is going to give an order to transfer it to a higher jurisdiction. So you still go through the magistrate's court, and you only start testing the evidence the same as they do now if the accused applies for a discharge. So if the accused says, I'm putting in an application to have this matter discharged before it gets to trial, because I think it's, spurious. I think that I've been, some accused people think that they've been targeted by the police perhaps, and the charges brought against them aren't realistic. But if they don't apply for a discharge, you won't go through the full test that currently occurs, which should speed things up, as a result, improving access, etc., etc. So really, really important to consider the principles of justice here again, and how this can improve access, this can improve fairness for victims if we were to abolish the test for committals. Second recommended reform, I can absolutely whip over this one. We introduced judge-only trials during COVID. I just talked about it for about 5 minutes. There is a recommended reform out there that we should make this a permanent fixture of our justice system. Hey, you should be able to have judge-only trials for all types of different criminal matters if people want them. The argument here is that juries aren't always the best placed bodies to judge on someone's guilt or innocence. This is particularly worrisome in our current social media climate. Anytime something vaguely newsworthy occurs, it spreads like wildfire over social media, and legal professionals out there, legal researchers and bodies, etc., have all suggested that this is actually limiting fairness for accused people, because people consume this media, see this stuff circulating on social media, and basically make the decision that someone's guilty before they know anything in more detail about the case. And if those people end up being on juries and they've seen all this stuff on social media, the person's not going to get a fair trial. So the idea is, if it's a really, really high profile matter, that an accused person might be able to request or apply for a judge-only trial rather than have their matter heard by a jury, is what the reform really is. It's interesting though, like, I've got a really good mate who's a lawyer, and if you ask him, he's like, nah, juries are better. Juries are more likely to lead to an acquittal. But in some instances, there's an argument for why a judge-only trial would be fairer for an accused person. So recommended reform, bring in judge-only trials on application from an accused person in some instances. And finally, this is, in a way, the original recommended reform. It's always just an easy one to remember and throw out there if you need to. I've provided, a bit of extra detail about who called for it and what they've called for. But realistically, this is one when you're clutching, you can't really remember anything. You can use it for civil law as well. It's just throw out there, hey, why don't we increase legal aid funding? Okay. This actually got voted on by the Australian Senate in 2018, and they said, hey, we should increase the funding. The federal government should contribute more money to states' legal aid funding so that more people can receive access to things like duty lawyers or even ongoing representation, as we learned about with VLA earlier in this area of study. The reason being that a lot of people are left unrepresented. They don't pass the means test. Legal aid has limited funding, so the means test is quite strenuous. It's hard to actually be able to receive legal support, and as a result, people who maybe need help to access legal aid are left unrepresented. The number of people eligible for legal assistance is below the 14% of people below the poverty line. Make sure, if you're talking about increasing legal aid funding, though, you are linking it to criminal justice. Okay, so that's where you're talking about an accused person, maybe an accused person who is unable to pay for their own lawyer, but doesn't meet the means test. Increasing legal aid funding would be fairer for them. They would have greater access if they could get a lawyer from legal aid. Maybe increased legal aid funding means more duty lawyers or an expanded duty lawyer program, which can improve access for people who are going to court on the day that they're in court, so on and so forth. So trying to link it to criminal justice, but how could increased legal aid funding improve the criminal justice system? Again, I talked about what discussion means here, and just really quickly going over these. Removing the test for committals, really quickly without getting into too much detail. disclosure is the legal principle that someone who's been accused of a crime must be given all of the evidence against them so that they can prepare a defence. It's unfair if they're not. Currently, our committal process achieves this because, as the part of the committal process, an accused person is given all that evidence and then they have the ability to test it. There is some, and the VLRC actually covered this off a lot, there is some concern that if you remove the test for committals, then disclosure is weakened because there is less of a requirement to give all of that evidence to an accused person, which could limit fairness. So that could be negative for fairness. But the VLRC did propose ways to improve disclosure if the recommendation to remove the test is taken on board. But as it says here, the whole idea of criminal proceedings is fairness, so just bearing that in mind, that if you change the committal process, could you impact fairness? But it's all about access, it's about saving time, and it could be fairer for victims because they don't have to give evidence twice. Increased funding for legal aid, it's all about access and fairness, and also equality. It puts you, if you have a lawyer, you're on equal footing with the prosecution. You better understand what's going on with the support of a lawyer. That's access, and then as a result, you can put forward the best case possible to get the right outcome, which is fairness. So great links to PRJs there with legal aid, and judge-only trials. Again, talked about this before. Could limit equality. Different trials result in different methods of resolution for the same crime, and not spreading the decision across a panel like a jury could limit fairness, but it's going to reduce potentially delays, allows people's cases to be heard quicker because you've got different streams you can go down, and the accused can choose the best option for them. They get to make that choice and put in that application, which is fair, and gives them some control over their process through the system, which is an element of access as well. How this has looked on questions in the past, just to consider, was this question 2018, I want to say off the top of my head, but it might have been 2019. The best way for individuals to influence lawmakers to reform the civil justice system is to appeal cases. This is actually content from 4.2. So how do we influence law reform? So that's through things like appealing cases, doing demonstrations, petitions, things like that. But it then includes, so discuss the extent to which you agree. In your answer, explain how one recommended reform may assist in achieving justice. So all it wanted you to do in your answer was include a recommended reform and basically be able to be like, hey, here's a reform that's recommended and here's ways we could influence Parliament to undertake it. So the only time we've really been asked about reforms and recommended reforms has been this kind of tack on that might be worth, realistically, it's not a count in terms of marks, but might be worth a couple of marks in total out of this 10 marker, and just explaining what the recommended reform is, but also how it assists in achieving justice. So that is really, really important looking at this question and thinking about the reforms and recommended reforms we went over, is how do they improve justice? And that means fairness, equality, or access. So how does the reform link to the principles of justice, not just what is the reform, okay? And that's a really important thing. You'll see here from the examination report, they said an explanation needed, an answer needed to achieve full marks, an explanation of how a recommended reform could assist in achieving justice. That is, the question did not require an explanation of the recommended reform. So you didn't need to actually just be like, hey, here's facts about it. You needed to understand how it could lead to justice. So that meant referring to one or more of the principles of justice. So it's really, really important that you focus on the how, which is really analysis and getting into discussion, not just what it is. And really clearly here as well, some students explained a reform that had already been introduced. The study design distinguishes between recent and recommended. That means that you cannot get marks if it says recent reforms and you do recommended. Vice versa, if it says recommended and you do a recent reform, you cannot get marks. So really, really, really important that you are able to put these in their two different boxes. Ultimately, how does that link to principles of justice? We've covered with the skill. So couple of extra links here. I forgot to delete that one out. That's an old reform, so we won't worry about that one. But I will include this one down the bottom. It's a great one to look at. It's the VRC project on committal hearings. It has all the info. It has an update on where they're at with the implementation. Currently, the government's been very coy on whether they're going to actually implement any of the recommendations, particularly because the Royal Commission into Police Informers and the use of police informers actually had some conflicting recommendations around disclosure. So the government kind of had to make a choice there. So you can get updates on that at that website, and I'll include that in the link below. As we said at the start, ideally, now that we're done, you know what some recent reforms and recommended reforms are, but importantly, you know how they improve our justice system, how they improve justice in terms of fairness, equality, and access. And that's the really, really important thing that you need to do with this to make sure that you're able to get the marks that are available on a SAC or an exam. As always, shoot us messages if you've got any ideas for different videos that you'd want. Pop them in the comments below. If you've got a SAC coming up and you're just watching this in the lead up, good luck. If you're reviewing your reforms at the end of the year for an exam, good luck as well. And remember, your challenge today is go out there and do something nice for someone. Talk to you soon.